Constitutional Law 2, Lecture number 1, Judicial Review. Dear student friends, you are aware that I am Dr. Aga Surya Rao, Principal, Retired Aided Law College, Maharashtra, India. After my retirement, I started delivering lectures and uploading the same in YouTube for the benefit of the students all over India. This is my 173rd lecture. So far, I uploaded around 145 lectures in English medium on various subjects, nearly 17 subjects. And I also delivered around 20 to 25 lectures in Telugu medium for the benefit of my Telugu students. Today, I wish to take up the most important topic from Constitutional Law 2. Earlier, Constitutional Law was only subject. Recently, the Bar Council, some few years back, the subject is split into two parts, Constitutional Law 1 and Constitutional Law 2. Earlier, I delivered sufficient number of lectures. I almost completed Constitutional Law 1 up to fundamental duties. And Constitutional Law 2 deals with Union Executive, Union Judiciary, Union Legislature, and center-state relations, services and all. So I want to pick out most important topics from examination point of view. This topic, judicial review, is very, very important and burning topic. This is not only prescribed for study in constitutional law, but also in administrative law. In addition to that, this every lawman, irrespective of status, whether he is a law student, law teacher, lawyer, judge, should have sufficient knowledge about this topic. So this judicial, before going in this lecture, I will let you know the meaning of judicial review and how it is exercised and how it is the judicial review function is discharged. So exercise of judicial review power takes place in some situations. Discharge of judicial review powers takes place in some other situation depending upon the nature of case. So before going to take up this topic, judicial review, its meaning, situations, various constitutional provisions and kinds of judicial review and its significance, let me take just 1 minute to pay homage to my reverend parents, late Ragapparao, late Srimati Kantaratnam, and my wife, late Balivada Tirumala Gauri, advocate and my co-author for various academic works. And I express my heartfelt gratitude to all the godfathers, including publishers who are instrumental for what I am now. I express my deep sense of gratitude to the publishers and publishers of research papers in internet whose works and I am making use for preparing this lecture. And above all, I deem it as a duty to express my deep sense of gratitude and irredeemable indebtedness to my student friends with whose cooperation I would able to do this academic work. I must be extremely grateful and deeply indebted to my student friends who are instrumental for what I am now. Now, I wish to take up the judicial review. In Constitutional Law 2, the syllabus tentatively is Union Judiciary, Union Executive, Union Legislature, Union Judiciary, Center-State Relations, Service Matters, and lastly, Amendment. These are the main topics. But however, I want to pick out the most important topics from examination point of view, and also in seminars also, there are so many seminars are conducted on this judicial review, judicial activism, independence of judiciary, center-state relations, services. These topics I will take up. If possible, I will give maximum lectures for the benefit of students. Now I want to take up judicial review in my first lecture. In course of time, I will take up the other important topics. Now, what is judicial review? What is judicial review? The word review means view again, examine again, check again. The review means examination of a particular fact in issue, particular question in issue, so as to find out its correctness or error, if any, or legality or constitutionality of a particular thing. Here, judicial review is the power of the court, the power of the court vested under constitutional provision or legal provision, civil or criminal, to review a particular fact in issue, a question of law or any government executive action, legislative action, judicial action, whatsoever may be, in order to find a re-examination, to check again, examine again whether there is any error, whether there is any constitutional inconsistency, whether there is any arbitrary action of any executive authority. So that is called the judicial review is some special power conferred on judiciary consisting of Supreme Court, High Courts and other subordinate courts so as to deliver pure and impartial justice. So the judicial power, judicial review power is exercised by the courts under various issues under different circumstances. Judicial review, the power of judicial, the power of review is a weapon in the hands of judiciary to check and control the executive, legislature, and also judiciary, quasi-judicial bodies, adjudicating authorities like tribunals, consumer courts, and other quasi-judicial bodies like and to correct to find out the irregularity. Simply speaking, by judicial review power from Supreme Court or High Court or subordinate court, basically Supreme Court and High Courts find out the correct by re-examining, by reviving, or by reinterpreting particular question in issue or fact in issue to find out the correctness and make necessary changes or modify it or delete it or remove it. So this is what is called judicial review in its simple meaning. So I read out, simplify. The term review means to view again or to refer again or to examine to find out an error or misuse, if any, to get corrected by making any change or modification or to delete or remove the same. This is my definition. I have created this, prepared this definition out of some sources. Now, judicial review literally means power conferred on judiciary to re-examine or reinterpret critically to find out the correctness or legality or constitutionality of a particular fact in issue. For example, suppose if any constitutional validity of a particular case. So before going to discuss this particular topic, dear friend, I want to tell you in brief the governance of the government. In every state or country, basically there are two bodies. One body is ruler, other body is ruler. Ruler is government, ruled people. So, ruled people. The government governs or discharges its functions or rules through three authorities, namely executive, legislature, and judiciary. Executive, legislature, and judiciary, the entire governmental functions are distributed in among three bodies, three authorities: executive, legislature, and judiciary. With the help of through these three organs of the government, through pillars of the government, people are ruled. People are ruled. So it is the duty of the government to ensure that a peaceful governance is peaceful governance is to be made possible to the people. No individual in the country should not subject to any injustice. Nobody should subject to any violation of fundamental right. Nobody should be subjected to any grievance out of irregular judgment or arbitrary decision given by judicial authority or quasi-judicial authority, or no authority should create any public nuisance causing threat to the human life, and so many things. Whatever, there are so many issues that affect the interest of the individual citizens. The matter may be reported by particular some person concerned or suo moto. The court will take cognizance of that particular issue, fact in issue, and correct it by exercising judicial review power. Sometimes the Supreme Court, High Courts, and subordinate courts, they exercise the judicial power in serious matters. The court takes serious action, then we can call it as exercise of review power by the Supreme Court or High Court. And if in normal issues, we can call it discharge of function. Discharge of functions. As you know, this as per Montesquieu, French justice, he coined the principle of doctrine of separation of powers. We followed the doctrine of separation of powers. Executive, legislature, and judicial functions are distributed between executive, legislature, and judiciary, but they are not strictly followed. That is why we can call, instead of distribution of powers, we can say that division of powers between the division of functions. Instead of telling distribution of powers or division of powers, the word separation of functions. Instead of saying separation of power, it is better we say separation of functions between three organs, because there is internal check, because judiciary encroaches on legislature and executive encroaches on the powers of judiciary and legislature encroaches upon the powers of this thing. In all these issues I delivered in a lecture in administrative law, doctrine of separation of powers. You can refer it for details. So now coming to what are the circumstances under which judiciary, basically judiciary article 32 and 226 are the main articles that confer judicial review power on Supreme Court and High Court respectively. But article 32 is the main article 32, article 136 and 137 of the Indian Constitution confer on Supreme Court the review powers, and article 226 and 227 confer on High Courts the review power. There are similarly subordinate courts also. There are some other constitutional provisions, I will let you know. And not only the Supreme Court and High Court, the review power is vested in district court and subordinate courts also, and criminal codes including High Court, section 397 to 403 Criminal Procedure Code 1973 is there, and in Civil Procedure Code section 114 order 47 also deal with this review power. And in addition to that, the inherent jurisdiction is there, ends of justice, that power is vested in civil courts civil courts under section 148 to 153b. All these aspects I explained in various lectures also in detail. But dear friend, when we want to know about directly, I am taking this subject because actually I have while starting this constitutional 2, I should explain in detail about union executive, then union legislature, judiciary and other topic. But first of all, I will pick out the most important topic and telling you. After this, I will let you know judicial activism, almost identical, and independence of judiciary, and then we proceed to other center-state relation. Amendment is most important, and these things. So now coming to the point, what are the situations under which the review power is exercised by the court? There are so many circumstances cited. Number one is consistence of constitutionality of post pre-constitutional legislations and post-constitutional legislations. This is first circumstance. So here we got our Indian Constitution on 26 January 1950, after three and a half centuries British rule, and that is yesterday we celebrated this 73rd Republic of our country, and now the Indian Constitution came into force in 1950 January 26. However, prior to our independence, so many legislations were passed during first, second law commission, third law commission, those periods. Like, for example, Indian Penal Code was passed in the year 1860. Indian Contract Act, Indian Evidence Act were passed in 1872. Transfer of Property Act was passed in 1882. Like that, so many acts are there. So here, so these pre-constitution legislations and post-constitution legislations means laws passed before the passing of constitution, and laws passed after the passing of the Indian Constitution we have to do. So there are so many laws or legislations in India. Central legislations, other legislations parliament passed by parliament, state provincial legislatures, laws passed by the state government and other local bodies under delegated legislation. But whether whatever law passed before constitution or after constitution, there are so many laws, legislations, around nearly 1100 legislations in India. But among all the legislations, the constitution is the topmost legislation. So there are so many laws. All laws are municipal laws, all laws are state laws, but constitution is the law of the land, the law of the laws. Constitution can be described as law of the land or national law, municipal law. It is described as supreme law of the land, law of the supreme law of the land or law of the laws. This means any law, whether it was passed before constitution or after constitution, whether the law was passed by the central legislature, parliament, or it is passed by the provincial legislature, that is state legislatures, whether any local law passed by the subordinate bodies under delegated legislations, any law must be any law is framed taking into consideration the principles of natural justice, equity and everything. So whether the laws before constitution or after constitution passed by central legislature or state legislature must be in strict consonance with or adherence with the constitution. Suppose the constitution in one article, constitution says something contrary to that, if any pre-constitution law, if any in Indian Evidence Act and Transport Act, some contradictory point is there, that point in Indian Evidence Act or Indian Penal Code is inconsistent, it is unconstitutional. So pre-constitutional legislations, legislation as a whole would not be inconsistent. Any part or any chapter or any section or subsection, clause or system. To what extent it is contrary or inconsistent with our Indian Constitution, that area should be revised or changed or deleted or by constitutional amendment. There are either by constitutional amendment, there are three doctrines I told in Article 13 Fundamental Rights in Part 1, that is doctrine of severability, eclipse and waiver. These doctrines, it will be corrected or by constitutional amendment it can be it done. So, in after passing of the constitution also, that is the legislations passed after 1950, it must be very carefully observed that no section or article or provision, clause or subsection should not be against or contrary or inconsistent with constitution. Similarly, under this, for every law in country, parliament cannot pass legislation. It will delegate the power to executive of the state to pass the laws of their own. Under delegated legislation through the executive, the state legislatures will pass legislation. Under delegated state legislation will give delegate power to delegated legislation to local bodies like municipal councils and etc. Quasi-judicial bodies, they make their own law. So this is the so all any so the under this Article 13 according to Article 13 Clause 1 which defines law is all laws before Constitution must be according to Indian constitutional provisions. According to Article 13 Clause 2, all laws that are passed after Indian Constitution must be according to the Indian Constitution. Otherwise, they are declared unconstitutional. So this is the position. And now, next second one is actions of executive, legislature, and executive legislature. So here. So there are the entire government functions are vested in three organs: executive, legislature, and judiciary. According to the separation of powers coined by Montesquieu, French jurist, executive must do only executive function, judiciary must do only judicial function, legislature must do only legislative function. Executive means president, vice president, attorney general, council of ministers headed by the president of Prime Minister of India. In central level, state level, governor, ministers, and council of ministers headed by governor. That is executive. Legislature, Lok Sabha, Rajya Sabha headed by president. Judiciary, Supreme Court and Supreme Court headed by President of India. Supreme Court and Sabha, Supreme Court, High Courts, all courts headed by Supreme Court, followed by President of India is judiciary. But in India, we followed the doctrine of separation of power, but instead of telling separation of power, we can say separation of functions, because as per this doctrine of separation of power, one authority should not enter into other authorities' functions, but you have to do your own job only, you should not enter my purpose. But in our India, it is judiciary encroaches upon executive and legislature. Legislature interferes in judicial and this thing. So this is our constitution. That is why there is internal checks. The internal check. Judiciary will check executive actions and legislative action. Legislature checks executive action and judicial action like that. If any judge is found guilty, and the legislature will remove him by impeachment move. Suppose any any action, executive action, government order, government GR, anything is made, then it will go to court. The court will set aside if it is unconstitutional. That is why first thing, the judiciary under the power of review can question any executive action or legislative action. Suppose the executive, that is a council of ministers, whether in state level or central level, if any law is, action, the executive action means it may be government order, government rule, or any term or condition made by the any ministry or CM office, Prime Minister office, anything, or any IAS officer heads. Executive heads, the various departments official, they pass any rule, it causes any harm, it is challenged before the Supreme Court under Article 32, and it is challenged before High Court under Article 226 or 227. anyway. Then then the court will call for that particular activity, that fact in issue, and will examine and reinterpret that particular provision. Suppose executive has taken any rule, passed any rule, it causes loss or damage to particular class of people, and if legislature passed any law, that law passed any problem. Suppose legislature passes some law, regarding pension. The legislature passes some law regarding any public activity. The aggrieved may approach the court, or sua moto. The court also may take cognizance of that particular act and decide. In that particular case, what happened is, what rule, what section, what legislation it has done, the Supreme Court or High Court will re-examine it, reinterpret it. What do you mean by interpretation? Any law passed by the, proposed and enforced by the executive. That is, the bill is passed by the concerned ministry, got approved by the council, and the bill is presented before the Lok Sabha. After approval, it will go to Rajya Sabha. After approval, it will go to President for assent. After approval from President, it will come back to the Ministry of Home Affairs. After thorough review, it will be published in a Gazette notification, where from what date that particular legislation comes into force will be specifically mentioned. There are various issues I told in previous classes. The same day the entire legislation passed, to what areas the provisions are affected, and what provisions will have immediate effect, what provision will come into force after 6 months, what provisions will come into force after this thing. A bill for original law, for fresh law, the same procedure. For making revised law, deleting old law, the same procedure. Suppose the Consumer Protection Act 1986, in order to delete and a new act was passed, Consumer Protection Act 2019. Similarly, Motor Vehicles Act previous where 1988 is there. In order to, for a new act is not passed, Motor Vehicle Amendment Act 2019 is passed. So like this, the procedure is same. When the court, when it comes into Gazette notification with effect from the same principle, that particular law is applied in a particular case. While applying that law, the judges must apply that very carefully, take into consideration what is the object of that particular legislation, with what intention the legislators made that intention, they will keep in mind, and how best they will be able to deliver pure justice, how best they will be able to protect the aggrieved party. All these things will be taken. That process is called interpretation. So the court will re-examine or reinterpret that particular fact in issue and take appropriate action. It may be if a court finds fit, that particular law or GR may be set aside, or if it is found proper, the petition will be dismissed. So this is with reference to review, judicial review. So the court not only re-examines executive action of government, GR, government order, and orders issued by the subordinate authorities, government officials, and a law passed by that. The court also review the judgment given by the same court or lower court. Article 137 of the Indian Constitution confers on Supreme Court to review the judgment given by the same court if challenged before the court. So like this. And similarly, Article 226 confer on High Court to issue various writs to protect the issue of writ of certiorari and provision will come under this review, come within the ambit of this review. And 227 will have supervisory jurisdiction over all the subordinate courts. And now, next one is, third one is protection of fundamental rights. Protection of fundamental rights. Part 3 of Indian Constitution guarantees fundamental rights. Fundamental rights are human rights. The human rights are basically two categories. Human needs are more essential and comparatively less essential. More essential human rights are listed in fundamental right, and less essential human rights are listed in directive principles. In course of time, with the development of the economy and standard of living, some needs in under part 4 are added in. some fundamental right, like just right to education, earlier added in Article 21, subsequently it is made independent fundamental right under Article 21A. So this is this aspect I explained in Article 21 and 22 various issues in my Constitution Law 1 paper. So that is why fundamental rights. So fundamental rights are inherent rights. Without these rights, a man cannot live. Right to equality before law, equal protection of law, freedom of speech, expression, freedom of religion, minority rights, and such rights are freedom of education, freedom of right to livelihood, right to privacy, and all these things are there. These are most essential rights. A man cannot live without these rights. That is why they are called fundamental rights. The Constitution, when the Constitution came into force, the preamble of the Constitution guaranteed all the citizens to ensure sovereign, socialist, secure, democratic republic. These aspects I explained in detail in preamble in part 1, and ensure legalitarian society, and to establish a welfare state, and to uplift the ideals and goals of the Constitution, and protect, provide guaranteed justice, liberty, equality, and fraternity. In that process, Part 3 of the Indian Constitution provides so many fundamental rights. So if any fundamental right is affected, if any by executive action or legislative action, if one's fundamental right is affected, then that aggrieved individual can approach directly to Supreme Court for protection of the fundamental right, because the Supreme Court of India is the custodian of fundamental right, and the state through Supreme Court guarantees fundamental right to anything. The fundamental right can be suspended only at the time of emergency. So our fundamental right is right to freedom. This can be suspended in grave situations like in COVID-19 pandemic. Our people's freedom is curtailed. Our Article 20 fundamental right under Article 21 is we cannot have any protection from our fundamental right in view of this corona pandemic, keeping in view the wealth and welfare of our people. Survival is more important rather than freedom, and lockdowns are made. The people are confined to remain at home. All these things are there. So this is about protection of fundamental right. If any, by executive action, Karak Singh's case, executive action, subsequently Maneka Gandhi's case, legislative action, the scope of Article 21 against executive action and legislative action and subsequent development, I explained in detail in Article 21, first cost one. So next one is constitutional validity of certain legal provision. Constitutional validity of legal provision, in some law, one rule tells one thing, in another subject, one section tells another thing. So for example, Section 9 of Hindu Marriage Act 1955 directs the wife to resign her job and go to stay with the husband, join the matrimonial society. And in Sarita case I told you. But the Article 21 of the Indian Constitution guarantees every citizen, irrespective of sex, race, religion, to stay anywhere in India, outside India, subject to visa and passport, and anywhere in India. But wife is working in Hyderabad, husband is working in Visakhapatnam. When wife is not coming to Visakhapatnam to join matrimonial society in the files, then the court will ultimately order the wife to stay working at Hyderabad to go and join husband. So here there was a challenge in Sarita case. Her fundamental right under Article 21, 91G is affected. But ultimately the court said it comes to review power. When any constitutional validity is questioned, there are so many cases. Article 19, Article Section 9 Hindu Marriage Act conflicted with Article 21 and 19(1)G of Indian Constitution. Minimum Wages Act is conflicted with Article 19(1)G, and there are so many. Section 27 of the Indian Evidence Act is conflicted with some CRPC provision. No one should be compelled to give evidence against his own. And these are the So many constitutional issues are there. Section 303, constitutional validity of Section 303 Indian Penal Code was questioned, and in medieval state of Punjab, and ultimately that section was detailed. This is another situation. And the next situation is conflict between central legislation and state legislations. There are three lists I told you. One is central union list, state list, concurrent list. Some subjects, legislation relating to certain subjects are passed by central government only, parliament only. Certain subjects are belong to state. Some legislation, so state is entitled to pass certain legislation, but some subjects are common. Some subjects are common to central and state. For example, police is in central list and state list. Education is in central list and state list. Some subjects are excise, exclusively state list. CST, GST, central list. Commercial tax, so state list. Like that, income tax, central list. So some subjects are in state list. Some subjects are in central list. However, some subjects are central and state legislation. So when state government passed a law, central government passed a law, these two laws may conflict. In such circumstances, the harmony is maintained. In mostly union list is given priority. There in some exceptional cases also, state list also will be, state legislation also may be upholded, but normally union list supersedes the state list. Article 251 and 254 of the Indian Constitution deal with this aspect. Now next, sometimes when an individual approaches the court for review, without the party concerned approaches the court for review of the particular fact in issue. Sometimes the aggrieved party will not go to court. Some stranger who is having interest in public welfare will approach the court for justice. For example, public interest litigation petition. MC Mehta, a leading lawyer in Supreme Court, filed so many public interest litigation petitions. So here, Delhi pollution case is there, Kamalnath case is there, deforestation, then Ganga pollution case is there, Delhi vehicular pollution case is there. So many cases are there. MC Mehta with Union, Bhopal gas leak, Oleum gas leak. So many cases are there. But this public interest litigation also I explained in detail in constitutional law 1, administrative law also. Here generally the person, there is a principal locus standi, like a cause of action in contracts. The cause of action means who is entitled to, who has the right to approach the court alone can approach the court. Stranger to contract cannot approach the court. Similarly, locus standi. Suppose the government passed a GO or GR, and parliament passed a law. Because of that law, a particular section of people are affected. For example, doctors are affected. Then doctors alone can approach the court. Doctors are having locus standi. Some government employees are affected, central government employees. They alone have locus standi, they can court. But there are certain circumstances in which, irrespective of locus standi, a public spirited man can approach the court. File a petition under section 33 of the CRPC in local magistrate court, or he can file a petition under article 226 before a high court, or he can file a public interest litigation petition before Supreme Court under article 32. Then the court will take cognizance of that petition and will provide. Because there are some poor people, suppose the pollution, there is no proper sanitation in the city, and some public spirit individual can file a petition in a local court or directly Supreme Court or High Court. Similarly, there are mosquitoes nuisance. There is no, similarly, there are downtrodden people, they do not have any water facility, drinking facility and other things, sanitation facility. Public private man can do. So the aggrieved people are the people in outskirts, slums. They are facing the problem. They are not competent enough to approach the court, but any active citizen, any law student or lawyer or any other responsible person from social organization can visualize this matter to the court by filing public interest litigation. Then then the court will exercise the review power and do justice. And next one is suo cases. Suo cases means the court will take cognizance of particular case if case is filed before it. But there are some cases, there are without any case, without any report, by hearsay, by viewing through social media. Suppose some gang rape of some tribal girl took place. Yeah, the Supreme Court came to know through some stranger or third person or lawyer or anybody or through media or newspaper. Then the court will take cognizance of that particular case and give justice. These are the various situations under which Supreme Court, High Courts and subordinate courts will take cognizance of the case and review the case, re-examine the case, reinterpret the case and correct the mistake or error or wrong or arbitrary action. And the next one is judicial action. Suppose if any lower court gave judgment without following the principle of law, rule of law, and if it is challenged before the higher court for review, and the court will take cognizance of it and call for the records to that type of powers are vested in local courts, district court, and according to 397 Indian Penal Code, 397 and to Criminal Procedure Code, district court and high court we are having this review power. 397 to 403 403 of Criminal Procedure Code 1973 provide review jurisdiction on district court and high court, and various provisions are there. The review power is review. The provisions relating to review power are provided under section 397 to 403 of the Criminal Procedure Code 1973 that came into force on 1st April 1974. And next, similarly, in civil courts also, district court and subordinate courts also are having this review power under section 114 and 114, section 147 and order 114 and order 57 of the section 114 and order 57 provide on civil courts for this review jurisdiction. So these are the section 114 and order 47 of Code of Civil Procedure 1908. Section 114 order 47 of the Code of Civil Procedure 1908 provide review power on the civil courts. At the same time, there is inherent power or ends of justice conferred on all the courts, right from Supreme Court to lower courts. Ends of justice are inherent power in the sense there in India there is a lawlessness. So many areas laws are not made. For example, government liability law is not. So many areas are not codified. Law of torts is not. Law of torts is not codified. Administrative law is not codified, and so many areas law is not codified. Law is not there. If law is particular area is not codified, law is not there. And if the law is there but is not clear, if the law is not clear, either lawlessness is there, no law is there. Lawlessness means government liability. There is no law in law of torts. When government is liable, when government is not liable, there is no law. It is called lawlessness. Uncertainty of law, unclear. In Keswanand Bharati versus State of Kerala, in 6-7, 13 judge constitutional bench decided, while deciding the amendability of the power of the parliament under Article 368, the court said the power of the parliament is unlimited, subject to protection of basic right. But in that particular case, the court said what is basic structure should not be affected or curtailed. What is basic structure was not defined. In earlier, some few items were included. In course of time, so many articles, so many items have been added in the basic structure. That is unclear. In such case, the courts use review power. So that is for this particular case. So lawlessness is there. In such cases, inherent justice, inherent jurisdiction, ends of justice is applied by the court, because in inherent justice or ends of justice means irrespective of what is there in law, irrespective of what is, whether there is a law or not, whether there is a custom or not, whether there is a precedent or not, what the judge finds fit, this is the only action that will give justice to the aggrieved party. The court, the judges are provided with such a discretionary power to give the judgment of their own without taking into consideration whether any law is there, law is there, without following the sources of law like legislation, custom, legislation, precedent, and other texts and aspects, other GOs and other documentary sources. That judgment, that power is given. So the inherent justice also can be exercised by the judiciary by exercising its review power to deliver pure and impartial justice. So these are the cases. So now, what are the constitutional provisions of constitutional provision? Article 32, Article 32, 136 and 137 of Indian Constitution confer on Supreme Court this review power. According to Article 32, Supreme Court issues various writ of habeas corpus, mandamus, prohibition, certiorari, quo warranto, and prohibition and quo warranto come within the purview of this judicial review, and other writs are there. In writs topic I explained and gave a detailed lecture in Constitution Law 1. Article 22 and 22, 26 and 27 confer on High Court, but under Article 226, High Courts will issue various writs, these 5 writs, and 227 is the High Courts will have supervisory power. In India, we have one Supreme Court and 25 High Court. All the High Courts are conferred under 226 and 277, and 226 writ jurisdiction, 227 supervisory jurisdiction over all the subordinate courts within the territory. Now, Article 372, Clause 1 confer power on the Supreme Court to look into the matter. Article 213, 13 Clause 1 and 13 Clause 2, wherein law is defined. Law means law. So, according to Article 13, law is there, law in force is there. Law means any rule, regulation, customary principle of equity will come in that. Law in force means law passed by the legislature and came into force. That is law. But both law and law can be corrected by this power with reference to determine the inconsistency or constitutional validity of the pre-constitutional legislations and post-constitutional legislations. Next one is central state legislations. So central government will pass some legislation. Central legislature parliament, state legislature parliament with reference to any central state matters. Then which union legislation will supersede or central legislation will state legislation will prevail. In such cases, normally the union legislation will prevail over the state legislation. In case of some emergencies, it may be referred to judicial review. Then the Supreme Court will exercise its review power and determine whether a union legislature will supersede over central. In central state relations, I will take up this topic. And the next one is legal. These are the constitutional provisions and legal provisions. Civil law, the civil courts, district courts and subordinate courts are vested with this review power under section 114, order 147 of the Civil Procedure Code 1908, and it also for 7 similarly inherent powers are vested in civil courts under Article 148 under section 148 to 130 153b deal with inherent jurisdiction or ends of justice. Then CRPC provisions, the criminal courts under section 397 to 403 are vested with review power, and under this district court and high court also will call for the records of the lower courts to review the situation. These are the various issues. And next one is types of judicial review. Types of judicial review. So the judicial review, types of review. Justice Syed Shah Muhammad Qadri. Justice Syed Shah Muhammad Qadri categorized judicial review under the three heads. Number one, judicial review to control the amendment acts. So here in Mrs. Gandhi's case, so many amendments, constitutional first amendment, 24th amendment, 25th, so many controversies took place. But Justice Sinha, Allahabad judge, was dare enough to deliver judgment against Mrs. Indira Gandhi as to the irregularities took place in her election, and subsequently Mrs. Gandhi brought so many drastic made so many drastic changes. She uplifted, she promoted the then Justice A.N. Ray as Chief Justice, superseding three senior judges, Supreme Court judges. They could not have, they filed writ petition, but still before they came for hearing, they resigned their posts. And subsequently, the Parliament, through Parliament, so many amendments were made to protect the interest of Mrs. Gandhi. In amendment chapter, I will explain in detail. Next to this topic, the most important topic from Constitutional Law 2 is amendment, and amendment I will explain you in detail. And that thing. So, constitutional amendment. So, judicial review in respect of so many reviews took place in Golaknath case, Sankari Prasad, Sajan Singh. Oh, so many wonderful judgments are there. I will take the opportunity to explain all these things in amendment chapter, dear friend. And next, first category of review is amendment acts to control, review and control, judicial review for controlling amendment acts to limit the hands of Parliament. Second one, judicial review to control central state legislation. There is a consistent and unstinted conflicts between central and states regarding the share of revenue. The Finance Commission I explained in one class, and the amount collected by from states is taken by government, and the government will appoint some finance commission. Every year finance commissions are appointed. They will decide the share of the concerned state. Every time state governments are not satisfied with share given by the center, if they ask 10,000 crores, government gives 1 or 2,000 crores like this. This conflict is there. So that is why to control the center-state relations, review power is explained, and to control the judicial review, to control arbitrary decisions of the judicial bodies. In India, you know, friends, the pendency of cases is very measurable. Chief Justice, our beloved Chief Justice N.V. Ramanaji explained, said recently in 18th July 2021 that 4.5 crore cases, 4.5 crore cases are pending, and 69,000 cases in Supreme Court, and remaining cases in 25 high courts and subordinate courts. So, in spite of, in order to clear the pendency, so many alternative adjudicating authorities were established. Lok adalats were there, consumer courts were established, family law courts were established, fast track courts are established, and Lok adalats are there, labor courts, so many. So the judicial power got transferred to, is vested with the executive heads like labor commissioners, and some tribunals are established. All these things are there. Lok Adalats, Tribunal Act 1988 was passed. All these aspects, alternative dispute resolution, I have given very good number of lectures. If you are interested, you can see, dear friend. Dear student friends, please don't wait for my lecture, because there are 170 lectures. If you delete 20, there are more than around 145 lectures on 17 subjects. If there is a lecture is delayed, you can make use of that. Because of no inspiration from, no activism from students, in view of the students find it difficult to go through my lectures because of this pandemic. No colleges, no examination, no subjective examination. Examinations, if any, online objective type. So they are not able to pay concentration. That is the reason why I stopped it. I have good inspiration. My main ambition, my only one ambition is to deliver all lectures on as many as 30 subjects. In view of delay on the part of the student, I stopped. It is not decent on my part to give more and more lectures when students are not interested. I did not like to trouble. That is the reason why I stopped for 1 month. And again, there are some students who are eagerly waiting for my lecture. At least for their purpose only, I have decided to prepare and deliver lectures. So please make use of it. Make use of it. And judicial review. So when in order to reduce the pendency, clear the pendency, so many cases were established. Lok Adalats, Legal Services Authority, Lok Adalats, fast track courts, consumer courts, so many courts. But in spite of that, these alternative adjudicating authorities also, so many cases are pending. So 4.5 crore cases 8 months back. Today the number is increased. So this is the position. In view of above, the judicial review is of great importance, and judicial review in India is of great importance and significant. It is described as basic structure of the constitution by the Supreme Court in Indira Gandhi versus Mrs. Indira Gandhi versus Indira Nehru Gandhi versus Rajnarayan case. Judicial review was described as this. Is the all entrepreneurial function. It is also described as interpretational functionary and observer roles. Interpretational functions and observer roles are being played by the Indian judiciary to correct illegality and unconstitutionality and error of law and other violation of principle of natural justice and all. And the preamble, one of the preamble auxiliaries is to ensure the all citizens of India equal justice, justice for all. So the alternative dispute resolution machinery envisages low costs and make it available to the poor people and speedy justice. So the government is making so many alternative steps. Still the pendency is not cleared because of so many problems. So these are the things. So now last point for discussion is limitations. So here the judicial review, there are some drawbacks also. The judicial review is restricting the hands of government and government, that is encroaching, restricting by reviewing political activity and executive activity and legislative activity. For example, in Andhra Pradesh, the government wanted to decentralize the administration and judiciary at one place, executive at one place, legislature at one place. But it is being challenged. And in Telangana, the government wanted to demolish old building and construct a new secretariat building. Earlier, the court gave permission. Subsequently, the High Court stopped, and again it gave permission. That is why some problems are taking place. It's right like that, because whatever, even though this government, state government is very powerful, headed by the chief minister, if GOA is passed, a law is passed, if it is challenged before the High Court is having power to stop it. Similarly, in central level, the union government may pass law or union cabinet may pass any executive order. If it is challenged, the Supreme Court can stop it. So that is why, in view of the act of intervention of judiciary by its review power, the hands of government are restricted when the courts exercise excessive review power, maybe suo moto or due to political interference. If our government wants to do anything, if it is prevented by the judiciary by review power, the people lose confidence in the government, people lose faith in the government. This is the topic with reference to judicial review, dear friend. Dear friend, I am taking very serious to deliver lectures. You believe or not, my post-retirement period, I wanted to dedicate completely for delivering and uploading these lectures. But if you make use of the lectures, I will feel happy. But I am taking very serious. I am referring not only textbooks but also so many research papers in the internet. I must be extremely grateful to thee. So what we read in a class, what we are taught in classroom is limited, because what you find in research papers is more. Because suppose I am a teacher, when I want to teach some particular topic, I take very little, I speak very little. Suppose I speak about so Article 20 Indian Constitution, I speak this much. Suppose there are number of articles, if you go through the articles, every author is having some talent, he is talented, he is preparing. If you do 4 articles, you 4 diamonds you can collect and make it as a gauntlet. So like that I am collecting, I am going through various articles published by civil service centers and legal services authority, students of national law schools and other prestigious universities. I am going through and collecting and not only following textbooks but also I am presenting this matter, and I am also acquiring some knowledge. So but passing is not important, because so I request you to take it very serious and follow my lectures, and I am going to continue my lectures for 30 subjects. I will fulfill my ambition. I will speed up the lectures.